and we continue with our activities, and we continue to, you know, to just to discuss what passionate us, and voila, that we are all together anyway. What is going to happen is that we're going to wait for a few minutes still to see everybody that, to just wait for everybody to connect. If anybody of you wants to say a few words, like who you are, where you're from, whether you've already participated to any of our in-person events, please feel free to do that. Otherwise, just mute yourself. Nobody? Oi, Sireca. I see Leon. Hi. Enrico. Maybe you know these names. I see Briag, which I think we have never met before, but we have exchanged emails. And probably I also see other names that in this moment I don't.
Hello.
Hi. Are you all in Luxembourg?
Yeah, hi. I'm David from Luxembourg as well. It's my first meeting.
Hi, welcome.
I'm very looking forward to listen to all information.
Thanks. We're going to try to make it a bit interactive, but it's
yeah,
a
sure.
webinar, so we'll try to manage. I'm not sure how that will happen, but I will explain it a bit shortly. I don't know whether it's going to happen very smoothly, but anyway, thank you, David, for being with us.
My name is Doug. I'm checking in from Helsinki.
Whoa! Hi, Doug.
Hello.
Are you also a Legal Hackers organizer?
I am part of the Legal Hackers Helsinki, and yeah, definitely want to hack the legal system.
Cool.
Access to justice is my thing.
Thanks. Douglas, have you already had have you had a computational law related event this month? How is the situation?
No, we have been in transition, our group. So we're kind of in disarray. We've just moved from like a really official group with a lot of bylaws and organizational overhead to just straight up legal hackers.
Okay, so that's quite of a change.
Yeah, so we're
in terms
letting
of
the dust settle on that.
Okay, well, it's I'm so happy to meet you, and I'm so happy to have you here tonight. Thank you so much for joining. And maybe we can also, you know, tell us about your events as well, so that we can join. We have no excuse anymore. We are online the whole time. Is it everything locked down in Helsinki as well?
Yes, pretty much. You know, I think Finland has been slightly slow to react, but also slightly slow to have been hit. So yeah, the streets are pretty empty. Most things are closed. Schools are closed. I think the government's handling it really well. I'm super happy to be here instead of my homeland of the United States. So I'm really happy that I'm a new Finn instead of an old American, because I feel bad for my country people.
Yeah, I imagine. Yeah.
But good to be here and happy to join this group.
I'm very happy. I'm very happy. We're all very happy. Okay, so unless anybody else would like to say hi or tell us where you're from, where you are, how desperate you are, how happy you are tonight. Reka, I see that you're laughing for the desperate. Okay, because I hear there are still people connecting. So let's say that I will go through a couple of rules, so to say. So as I was saying before, this is our first online webinar. So it's a kind of, I mean, we're trying out some functionalities of Zoom. So we'll try to do our best, although if there is something not perfectly working, that's probably our fault, but we will learn for next time. So as you can see, I don't know whether you're already familiar with the Zoom, but anyway, what is going to happen is that at the beginning of the presentation, so what I'm going to introduce tonight, I would like everybody to mute him or herself. so that we don't have any kind of echoes and problems with sound. This is very important. You can open the chat tab. The chat is like a bubble, speech bubble icon on the bottom part of the screen. If you open it, you can see what everybody's writing, and you can also write, of course. How we're going to try to moderate this event tonight is that we have a main speaker. He has a presentation, a very interesting presentation. Of course, it's a bit different than in person, as you can imagine. So what is going to happen is that if you have questions or comments, you can write them down in the chat. I will take note of those and ask them to the speaker afterwards. This is for during the presentation. After the presentation, of course, it's going to be easier if we just write comments or questions, but of course, it's also possible to make it also more interactive to ask your questions with your voice. For doing so, I would ask you to actually ask me to take the floor. So you write me in the chat, can I speak or can I ask a question? And I take note of the order of the people asking that. So just for a summary, recap for anybody that has connected in the last minute or so, mute yourself. There is a chat. You can ask questions and write comments on the chat. I will ask them afterwards to the presenter. At the end of the presentation, we would like to have a discussion. So we'll try to do like this, that either you write it down, or if you want to speak, you ask me to speak and I give you the floor. With this, I would say that we can start. Let me see, how many people are we? 29. Oh, that's a lot. Thank you for being here, even if we don't offer beers as always. So that's pretty nice, actually. So I will, let me see whether you can see my screen. And voila. Okay, so everybody mute yourself. And welcome again for being here. Thank you again for being here and welcome to everybody. We are Legal Hackers. Legal Hackers is a global community. We're everywhere. However, this is the Luxembourg chapter. And we have a community that promotes legal innovation. And especially what we do, what we aim is to create and foster an open culture for law. And we're specifically interested about any kind of topic that is at the intersection of law and technology. And we have, as you can see from our meetup page, we have already had some events in Luxembourg. Our chapter is pretty new, is 1 year old. But we do, like, we have been dealing with legal design, with privacy and cybersecurity, and with many other topics, blockchain, of course. So this is the map of the Legal Hackers chapter all over the world. So as you can see, we're everywhere and we're many, and we're growing. Actually, we're exponentially growing, not as fast as the coronavirus, but that's where we aim to be. But as you can see, we're many, and we're getting more. And we're very happy to have every time new members on board. And as I was saying, we're globally present, but we try to tackle issues that are relevant for the local context. And tonight we are organizing an event within Global Festival, which is the Computational Law Festival. So there have been chapters all over the world organizing events within this festival. You can check the website, even our meetup page, to see, there is a link to see what other people have been doing all over the world. And we have chosen the topic, computational law and open data. And to tackle this topic, we have invited Enrico Francesconi, who is a very, well, for some of us, we have been knowing him for a while. Enrico Francesconi is a researcher at the Legal Informatics Institute of the National Research Council of Italy. But he actually lives in Luxembourg because he works at the publication office of the European Commission. And he's a very versatile person and researcher, and he has, yes, he deals with a lot of topics that are very relevant for computational law. And specifically, he's expert in semantic web technologies for the legal domain, legal knowledge representation, AI for legal document classification, and automated legal reasoning. So tonight we will get a glimpse of all this very wide and complex domain. And we'll try also to discuss what is relevant for you, for your activities, for your daily activities, or what kind of ideas you can have. And I would like to stress that we have co-organized this event with Let's Block, which is an association based in Luxembourg, focusing on blockchain technologies. I'm not sure whether Monique is there. I haven't seen her. We'll see. And I would also...
Hi, yes, I'm on.
Yeah, hi, Monique, sorry. Hi.
Hey, everybody.
Wonderful. So Monique, if you want later, you can say a couple of words before our speaker starts.
Okay.
Okay, wonderful, thank you. And I would also like to thank Harness, the law firm, because it is the one that provided us with the webinar, with the tool to hold this event tonight. So special thanks to Harness. Just if you'd like to tweet, we're very super happy about it. We have a couple of hashtags that we usually use. Actually, we use legal hack usually. For tonight, we also have the special hashtag hack the virus, because we thought it was important to hack the virus and be together as a community. Very happy to have tweets for tonight, so go ahead. One thing that I should mention is that we are recording the video, and we're recording tonight's event. So if you wouldn't like to be present, tell us. Even afterwards, we can either cut the video or blur your face and what you write, so there is no problem. But as a matter of fact, we are recording this event. Yeah, and just a little teaser for our next event, which is going to be in 1 week from now, on April 1st. We're going to update the information on our meetup page, so follow that. And it's a wonderful initiative by one of our co-organizers, which is Victor, who is also online, friends, who have been developing a chatbot that can answer legal questions concerning coronavirus. So we have invited them to present this initiative next week. If you'd like to join, we would be very happy to have you there. And I think it would be great also to see whether we can somehow contribute as a community in Luxembourg. That's it for the moment. So if you'd like to follow us from our channels, Twitter is Legal Hackers Lux, Meetup is Luxembourg Legal Hackers. It's the only way to be updated about what kind of events we have, and also for register per event. So if you want to sign up, and also we have a LinkedIn page, Legal Hackers Luxembourg, the company. With this, I'm done, and I would maybe then leave the floor to Monique for introduction about Let's Block, and then we give the floor to Enrico. Thank you.
Hi, everybody. Yeah, so I'm Monique Bachner, and I'm the chair of Let's Block, which is the Luxembourg Blockchain Association. We are a community-based association focusing on all aspects of blockchain. One of our key projects at the moment is launching our own internal chain called the Pulse, which if you're interested in, you can come and join, and it'll be used as a learning tool. So how to run a node, how to issue tokens and so on, exchange them, but as a learning tool for the members. And then we choose topical issues, over time, smart contracts, regulations, a lot around cryptocurrencies and financial services legislation, AML, etc. But also technical things to do with blockchains, or in this context, legal questions. So have a look at our website, www.letsblock.com, and hope to see you all at one of our events in future as well.
Thank you so much. Thank you so much, Monique. So yeah, go check it out. Let's Block. I'm also very happy because, yeah, we have a long story of collaboration with Let's Block. So thank you so much for being here tonight. And voila, well, Enrico, I would say that the floor is all yours. And if you'd like to start to share the screen and to say a couple of words about yourself, we're here and we're happy to hear. Thank you so much.
Thank you very much, Arianna and Monique, for your kind introduction. And I'm very happy to be here. I'm very sorry not to be able to meet you in person due to the hard problem that we are facing all over Europe. So I'm going to start providing this presentation. Just let me share the screen. Just one second. Okay. Okay, so I hope that you can see my screen. So in this presentation, I'm going to show an approach that is basically conceived in a linked open data framework. And the objective of this approach is to transform regulation in machine readable or actionable rules for automatic legal reasoning. The aim is to present, let's say, this approach in a pure semantic web-oriented approach according to a linked open data decidable profile, which means basically to have the possibility to guarantee the computational tractability of the problem for two main different different approaches that we are going to present in this presentation, that are basically the advanced legal information retrieval and norm compliance. The aim is to show this approach also that can handle norm defeasibility. So the approach that I'm going to show is basically based on the distinction between provisions and norms, which are basically two concepts that are well known in legal theory. If we consider that the legal order can be seen as legal discourse composed by linguistic entities, also speech acts. And every linguistic entity actually, so what we can see in a legal document can be seen in a twofold perspective. In terms of provisions, which means a set of signs organizing words, sentences for creating a normative statement, and a norm that basically is the applicative meaning of a rule within the social reality, let's say. So we can be, let's say, more convinced of the distinction between provision and norms. So the fact that they are actually two different objects when we consider that a provision can include more norms and a norm can be expressed actually by different provisions. So in the same piece of text, you can have actually different norms, and a norm can be also expressed by different provisions in a legal text. Moreover, a norm and a provision are two objects that have actually two different relationship with respect to the time. For example, a provision, which is actually a pure textual object, are the product of the lawmaking and are characterized by the so-called enforced date. So basically, a provision can enter the legal order or can be amended or can be repealed by other different provisions. So basically, the time that characterizes a provision is actually the enforced date. So the date in which the provision enter into the legal order. But a norm, which is actually an applicative interpretation of provisions, are characterized by a different type of time. For example, the efficacy date, which is the starting date in which a norm can be concretely applied. Actually, we can see here in this table the two different configuration of the different type of time that a provision and a norm can follow. So a provision can be enforced and the norm, related norm can be effective. A provision can be enforced but not effective. Or we can have also the more specific case in which a provision is no more enforced, but the norm is still effective. And this is the case of a retroactivity or ultra-activity of a norm. So basically, we have we can say that provision and norms are two different objects. One, provision is actually a textual object, which is well suited for reasoning with the textual information. In particular, we can consider provision when we want to deal with advanced legal information retrieval, like, for example, dealing with Opheldian reasoning. So basically, it means that we want to retrieve a specific provision, like, for example, a right for a subject, and having back also the correlative provision where the subject is actually, in this case, the counterpart. But we are going to see later the specific example.
Sorry if I have to interrupt you, but we cannot see the slides passing. Are you moving the slides, or are you still on the main one?
No, no. I have actually went through the slides.
Ah, okay, because we cannot actually see them. I don't know whether you shared the right screen.
Sorry, I'm very sorry for that. Bring your.
Don't worry. Sorry for interrupting.
No. I can later. I can even show more. Try to show again. Let's see.
Because usually when, yeah, you can share different screens on your.
Yeah, but actually, let me try again to share.
Okay.
Share. New share.
So we now.
New share, but it seems not to be working.
Now we just see your screens. Maybe you can just go through the slides like this.
Let me try. View full screen mode. Can you see now?
Not yet. Yeah, okay, just try to move forward and backwards. Okay, yeah.
Yeah, but I cannot now go back and forth. Oh, now I can go back and forth.
Okay, yeah, I think now it works.
I'm sorry, I'm very sorry. So I don't know if you can see the first part of the slides. I was here. I don't know, I can continue from here. So basically the slides with the title, provisions and norms in legal reasoning.
Perfect.
Okay, I'm sorry for that. So as I said, in this basically in this approach, we are dealing with these two kind of objects. The first type of object is something that we used to call provisions, which means an object which is actually a textual object. It's actually what is written in a legal text. And usually when we want to reason with textual information, we actually talk about provisions. So basically like a type of reasoning like advanced legal information retrieval or legal drafting. And when we want to reason with an interpretation or application of legal rules, we actually talked about norms. So basically a typical case of reasoning with norms is actually the legal compliance checking. So we have actually an event in a social reality, and we want to know if this event is compliant or not with a certain regulation, which is what we used to call a state of affair, if a state of affair is compliant or not with regulation. So basically, in order to deal with these two different objects, we have actually approached the problem in two different aspects. In order to model provision, we actually created an ontology, which is actually a provision, a taxonomy of provision, so a classification of provision types, which is used for semantic annotation of legal text. On the other hand, norms can be modeled in this approach in terms of a domain ontology and ontology restriction. And we will see later what we have, some example of this kind of approach. So let's consider now the first part of our approach. So how to model provisions for semantic annotation and advanced legal information retrieval. So let's consider a typical use case, like a user that wants to subscribe an online contract, and he usually can be willing to know his rights, for example, according to the protection law. And in particular, he can be interested in consumers' rights, like the right of withdrawal, or the supplier's duty towards the consumer, like implicit rights of the consumer, which is the typical approach of the so-called Offeldian reasoning. And the procedure to fulfill the consumer duties and the sanctions in case of non-compliance. So in order to have a system, so there is not you cannot approach this problem, this, let's say, information need of the user using a general purpose search engine. But you have to deal with semantics and with a semantic search engine. So what we want to have is a retrieval system of legal rules endowed with reasoning facilities. So in order to do that, one of the main, one of the possibility is to consider a legal text, or let's say a set of information of a legal text in an archive, and having them semantically annotated with the model of provision that we have previously shown. In particular, this is an excerpt of a EU Directive on consumer law that can be considered, according to former profile, as a set, as composed by a set of paragraphs. But from the point of view of the semantics, it is actually, can be considered as actually composed by a set of provisions, and each provision has its particular semantics. For example, the first paragraph for the Article 5 is the duty of the suppliers towards the consumer. The second paragraph is the procedure of the suppliers toward the consumer. The third is the right of the consumer towards the supplier, and so on. So in order to have this semantic annotation, we can use actually a provision model, so an ontology that contains all these different type of provisions, like, for example, what we used to call constitutive rules or regulative rules, or in particular for the regulative rules, deontic norms, providing rights and duties, so permission, obligation, prohibition, and so on. And the related properties of them. So in order having a set of legal documents annotated using the provision model is a way to implement the semantic web in the legal domain. So like in the semantic web, actually we pass from the web of document to the web of data. In the legal semantic web, we pass from the web of legislative documents towards the web of normative provision, because actually legal users, legal experts are more interested in knowing the content, or of the provisions, the semantics of the provision, rather than the whole document. So a provision-centric view of legislative text can contribute to transparency, because actually the semantic annotation of the part of the text provides more facilities for retrieving a portion of legal text according to their semantics. Like, for example, so implementing semantic search facilities based on legal rules. It allows you to implement a consolidation, automatic consolidation of legal text when you have the possibility to describe the semantics of the amendments. Or having the so-called analysis of coherence and impact of new text on the legal system. So checking contradictory norms or regulative impact analysis. And finally, legal drafting based on semantics. But in this very presentation, we are going to focus the attention on semantic search facilities based on legal rules. So let's consider again the examples that we have shown before. So we have a legal text where the semantics of each provision contained in each paragraph are explicitly expressed. So at the beginning, we have the duty, the procedure, the right, and so on. So what we would like to have is a system that allows you to query an archive of a legal text. For example, like in the use case we have shown before, for the consumer, which might be willing to know his rights when he subscribes an online contract. So he wants to know which are my rights, for example. But the system, in this case, can give you back not only the right where the consumer is the bearer of this provision, but also the duties where the consumer are counterparts, because they are actually rights of the consumer itself. So basically, and this is the typical, as I said before, Opheldian reasoning that implements actually the reasoning developed by legal philosophers in the past. Or, for example, allows you to search the system in terms of give me the duties of myself, for example, which I'm a supplier of a service, and the procedure to fulfill my duties. So in order to implement this, as we said before, we have represented provision types and the attributes according to the provision model, so the taxonomy of provisions. And we can express axioms on provision types and attributes, as we can see later. And what is important to underline is that this approach uses a pure semantic web methodology. So basically, all the standards that are suggested by the semantic web and the linked open data approach. So RDF for expressing statement, and OWL, in particular OWL-DL, so description logic for creating ontologies. And the fact that it's an OWL-DL, it means that it guarantees the computational tractability of the approach. So you can use already existing reasoners, which are already available. So general purpose reasoners. And Sparkle as a query language, which is actually the query language, which is also suggested within the guidelines of the linked open data. So in order to implement, for example, the Opheldian reasoning that we have seen before, we can observe that, for example, a right of the consumer can be explicitly expressed, but can be also expressed in terms of the duty of a counterpart, which is actually not an explicit right expressed in the text, but it's an implicit right. So what we have done in this modeling, we have extended the typology of the provision types in terms of explicit right and implicit right, or explicit duty and implicit duty. And actually, we have established equivalence relation between implicit right and explicit duty, and implicit duty and explicit right. So this is the same holds for the properties. For example, the fact that the implicit duty of the bearer are equivalent to explicit right of the counterpart, and so on. So which are basically the main advantages, the main benefits of this approach is that the fact that we have expressed properties equivalence, which allows you to have a direct check on attribute context. So basically, we don't have any conditional statement in your query or in your reasoning, which is usually a bad practice. For example, when you usually in software programming, but also in reasoning, in particular legal reasoning. Or we have used abstract classes like implicit classes to approach and to have a vision of different different views on the same provision, like implicit and explicit one. And something that has to be underlined again is that we keep the problem within the description logic complexity, which guarantees the computational tractability of the approach without using any other kind of tools like SWIRL, so Semantic Web Rule Language, or RuleML. So basically we use just ALDL and Sparkle as query language. So, which means that you can use the reasoner that are already available, like, for example, Pellet, which is the Java-based ALDL reasoner. And the result, for example, in this case, is a provision model where inferences are calculated from the asserted axioms. So let's have a look at some examples. Let's consider that we want to query the system in order with this kind of a Sparkle query on property types or property values. For example, I want to have the, let's say, the rights where the consumer is actually the bearer. So this is the type of a query that you can submit. So in the asserted model, what you retrieve is actually nothing, because you don't have anything here expressed in terms of the right of a bearer, because you have actually expressed your semantics in terms of explicit right or explicit duty. But when you use the so-called inferred model, so basically after the reasoning of your automatic reasoner, you have the possibility to retrieve back the explicit right where the consumer is the bearer, but also the explicit duty where the consumer is the counterpart, because they are actually implicit rights of the consumer. And this is made possible thanks to the relationship that we have established between equivalence, between explicit duty and implicit rights. So what is important is that this approach can be implemented with very generic tools like XHTML for structural markup, in case you can use a qualified modality for having the semantic annotation XHTML, but in particular using RDF for semantics, nothing but RDF. So let's have a look at the second approach, so modeling norms by domain ontology for legal compliance checking. So it's the second, let's say, the second element that we have introduced at the beginning in terms of specific conceptual object dealing with norms. So before we have managed textual aspects, which are well suited for reasoning in terms of legal information retrieval, for example, or other kind of reasoning that deals with textual object. Here we are going to deal with conceptual objects, which are well suited for example, legal compliance. So while provision is a textual expression of a legal rule, and as I said, is a textual object, a norm, and in particular a deontic norm, so an obligation, a permission, or a prohibition, is the application of a legal rule to the social reality. So basically, people, or let's say other entities in the reality can interact and act freely. But when you are actually, you want to know if a specific entity or a specific agent is acting according to the law, you can have, let's say, a check of the compliance of this activity with respect to a specific rule. And in this case, a norm is a conceptual object. So in our approach, the reality can be represented like a domain ontology, so without any specific legal implication. But the deontic notions can be represented as a constraint on the reality, because it's actually what a law is doing with respect to the reality. It provides constraints to the different, let's say, free, the degree of liberty of agents and interactions. And the legal compliance checking means identifying individuals of the social reality which are compliant with such constraints. So let's have a look at some examples. Let's consider this piece of regulation, which is actually the Article 12 of paragraph 1 of the GDPR regulation, of European regulation on privacy, let's say. So in this paragraph, you have the controller shall take appropriate measure to provide any information relating to processing to the data subject in a concise, transparent, intelligible, and easily accessible form, and so on. So what does it mean, basically? It means that the subject, the agent of this provision, which is actually a textual object here, can be considered also in terms of norm, has an agent which freely interact in the reality and can provide information on data processing or not. So basically, you have the concept controller. Here the prefix means my ontology, just a fictitious one, which can provide information on data processing or not. And this aspect can be represented using a specific property, data type property, that can have a value false or true. So basically, in order to know if a specific individual of the type controller is compliant or not with this regulation, we can actually, or in order to, let's say, to represent the fact that a controller is compliant to this regulation, you can introduce a data type restriction identifying controllers that are compliant with the norm Article 12, paragraph 1. And this constraints basically identifies controllers having the value true on the property, provides information on data processing. You have to it's good to underline that this subclass relation is actually something that is automatically created by the reasoner. So in order to now to select individuals that are compliant to the obligation, what you have to do is simply to express a query like give me all the individuals that are individuals of the class controller, Article 12, paragraph 1, compliant. So in this case, the individual C2 is an individual having the value true on the property provides information on data processing, and is actually an individual which is compliant to the norm expressed by the Article 12, paragraph 1. Let's consider another example, and this rule R1. The supplier shall communicate to the consumer all the contractual terms and conditions. This is clearly an obligation of the supplier. And if you consider it as a sort of textual information, you can, as we have done before, you can annotate the text in terms of provision type. But when you want to know if an individual is compliant or not with this rule, you have to think in terms of norm. And in particular, you have to represent the social reality as an ontology. For example, you have a class of supplier having a specific property which is has communicated conditions, and this property can have the value true or false. And again, in order to express the norm represented in R1, you can introduce a data type restriction representing norm R1, which is actually which identifies the set of individuals, of suppliers, having on the property has communicated condition the value true. Again, this subclass is automatically created by the reasoner once you have expressed this restriction in your ontology. So in order to know who are the let's say the individuals that are compliant with the regulation, you can simply submit a query. Let's consider it here. You have two instances, S1 and S2, which are two suppliers here expressed in XML RDF serialization. But basically, you can focus your attention on the picture upward, and you can see that S1 is actually an individual having the value false on the has communicated condition, while S2, which is also a supplier, but is in particular a supplier which is R1 compliant, because it has the value true on the has communicated conditions. So in order to retrieve just the individuals that are compliant with this norm, you can provide a query like, give me just the individual of type supplier R1 compliant. And the system does select just S2. Finally, another example, dealing with not, let's say, Boolean values, but with continuous, so floating point values. Let's consider this R2 rule. According to a country law, one cannot drive over 90 kilometers per hour. So in your reality, you have a driver, and this driver can have a driving speed which can be whatever, from 0 to 300 kilometers per hour, for example, of what you want. But now, in order to express the constraint expressed by the norm here, R2, you have to provide a data type restriction representing norm R2, which actually identifies the driver which are having on the property driving speed values between 0 and 90 kilometers per hour. So basically, you can have here 4 different, let's consider you have a meter on your motorway, and this meter detects the velocity of the speed of different vehicles. So this meter can record the fact that D1 has 50 kilometers per hour, D2 60 kilometers, D3 85 kilometers, and D4 has 95 kilometers. So now the system, using just this approach, is able to classify automatically these individuals in the class driver or in the class driver R2 compliant. So in order to know which are the individuals which are compliant, you can submit a simple query like in Sparkle, give me all the individuals that belong to the driver R2 compliant. And the system just selects D1, D2, and D3. Finally, the very final part of the presentation, the fact that this approach can handle norm defeasibility for legal compliance checking. So what does defeasibility means? Defeasibility is the property of an argumentation system for which a conclusion is open to revision in case of evidence to the contrary is provided. In particular, for legal reasoning, and in particular for dealing with legal text, norm conflicts or norm exception might breach a previous conclusion, which is what we used to call non-monotonic reasoning. So let's consider an example, the very last example that we have considered. Let's consider the rule R2. According to a country law, one cannot drive over 90 kilometers per hour. And this is valid in an interval between, let's say, 0 to T0, which, for example, is last year, let's say. Now, the next year, the following year, the regulation changes, and it says that according to a country law, one cannot drive over 80 kilometers per hour. So the new version of R2 can defeat the previous compliance conclusions, and individual compliance with the previous version of R2 might not be compliant with it anymore. And in fact, this is what happened. This is the model that we have seen before. We have D1, D2, D3, which are compliant, while D4 is not compliant. But the regulation tells you that your speed can be up to 90 kilometers. Now the regulation changes and you have an updated model for R2. So what you have is actually a new constraint in your has driving speed property, which actually is a restriction which tells you that you cannot drive over 80 kilometers now. But what happens without changing anything in the model and neither in the data? You have a reclassification of automatic reclassification of the instances in terms of compliant instances and non-compliant instances. So you have now D1, D2, which are the only two compliant individuals, while D3, which before was compliant, is no more compliant, like D4 is no more compliant. So basically, as a conclusion, we have presented a framework for decidable legal reasoning based on the distinction between provision and norms, and in particular, either legal information retrieval or norm compliance do not make use of any conditional statement, for example, and moreover, it is actually manageable in a decidable profile, semantic web profile for tractable reasoning in the legal linked open data cloud. So we use just decidable fragment of OWL2, which means you can use just the existing technologies and the existing software already developed. The approach can handle defeasible reasoning. And that's all, and thanks for your attention.
Thank you so much, Enrico. Thank you so much for this very clear presentation. We have for the moment one question, and I will ask one question from my side, and then maybe we can even open the floor to the others. So first question is, will you be able to share the slides after the meetup?
Sure, no problem.
Okay, wonderful. So my first question, then I will go and see the dog has written something, is, so with the approach that you have been explaining and the tools that you also showed us, what kind of applications are you actually developing at the European Parliament, and for which users? So who is actually going to use those?
So basically, this is actually the result of a study in terms of theoretical study. It's not implemented at European Commission, where I'm currently working. What we are doing in the European Commission is to deal with, let's say, to prepare the ground for third parties to reuse data or legal data and to provide added value in terms of a semantic annotation according to two different models, like, for example, the provisional models, or, for example, the norm representation that I have shown in my slides. So basically, at the Publications Office in particular, we are managing probably the largest repository of legal acts, which is called the Seller, which is a semantic web repository of legal but also non-legal materials produced by the European Union. So we have documents coming from the Commission, coming from the Parliament, from the European Court of Justice, and we actually have developed an ontology, which is an ontology which provides mainly bibliographic information. What is important to say is that Seller gives also is endowed with a so-called sparkle endpoint. So you have the possibility to retrieve those data and to reuse them according to your needs, or also even to develop a specific business, let's say. The approach that I have shown, it's a step forward, in the sense that on the ground of on the basis of those data, you can have the possibility to provide a semantic added value for let's say semantic annotation of text, and to provide your customers or final users with additional services, which are more than just retrieving documents according to the details of the act, for example, the date of issue, or the issuing authority, or the type of measure. But what you can do is something like give me back just the rights of myself, which I am, because I am, for example, an entrepreneur who wants to establish my business in a specific country, and I want to know which are the specific regulation and which are the rights or the duties for myself. And I don't want to read the full set of documents that might be retrieved from a document-centric view. What we show here, it's more a provision-centric view or a norm-centric view.
Okay, thank you, very clear. So yeah, so it's actually you're providing the data, marked up data, and also endpoints where people can actually query the data, and then it's up to businesses and other researchers and developers to develop their own applications for their
exactly. So to implement their specific models, and these two that I've presented here are two possible models for let's say providing added value to enrich the data that are already provided according to the semantic web let's say standards.
Okay, wonderful. So I see that we have a comment already from Doug. I don't know if you are able, Enrico, also to see the chat, but then what he's saying, as far as I understand, is that saying, you know, like it's not a yes and no answer, right? It's not only a Boolean value, but there is a qualitative question. And now how you actually say that something is transparent, understandable, clearly legible, etc. So it's a very hard question for a machine to answer. Do you have any comments on that?
I'm just going through the question. So just
at the end.
Yeah, okay. There is a question. You mean that if I well understood, you are let's say dealing with the problem of possible interpretation of the text, which cannot be, let's say, simply expressed by a semantic annotation. This is actually true, and it's also something that has been, let's say, discussed also in the legal, in the AI and law community. But what you have to consider here is that this annotation is not provided in terms of official annotation from the issuer. So let's say the institutions that provides this information, but it's just has to be considered as a sort of additional service that can be given by, for example, a publisher or by whatever third parties of a legal firm you want to their customers. So it's actually up to them to implement at the degree of complexity that they want to approach. Moreover, you have to consider that these models can be implemented in an automatic or semi-automatic fashion. Let's say, for example, the annotation of a provision, so a piece of text in terms of provision can be obtained using an automatic classification approach. So let's say like with using machine learning or natural language processing facilities. Also in this case, you can have a bias, or you can have difficulties in the interpretation, but you have to consider that the annotator can, let's say, intervene and change the prediction of the machine or not.
If I also can add something on top of that, specifically about this question, actually, Doug, is that, for example, specifically talking about transparency, what we are doing, I work at the university, so it's a matter of research, but of course, we're also thinking about practical applications. We are exactly trying to define what it means from a computational point of view, transparency. So all these properties that we have been reading about, it was, you know, like understandability, legibility, accessibility, and it is actually possible to give formal definitions of those properties to define them, so that actually it's even computable whether some kind of communication is legible or not. For legibility, it's very easy because we have, you know, the reading formula, reading level formula, but also for other properties is actually possible. So maybe integrating different tools, then we can, of course, it's always an interpretation, but at least it's a very transparent interpretation, so it's very clear how you got there. So I think that by in integrating different tools, maybe that is something that is possible to achieve, even if partially.
Yeah, moreover, sorry, Arianna, if I interrupt
Yes,
you, but this problem of interpretation does exist also in the from the human point of view, because sometimes also for humans it's not easy to give let's say just one interpretation of the same provision. This is not the case usually. So it exists from the human point of view and also from the machine point of view.
Yeah, that's very true.
Yeah.
But indeed, as you were saying, Doug, it's not like just solving problems, computing everything. It's not a straightaway process. So Reka had a question. So Reka will give you the floor.
Yeah, hi, thank you. Hi, Enrico.
Hi,
I'd like to ask you that you mentioned that norms, especially deontic norms, are to be considered as constraints on reality. So my question would be that what other types of norms do you consider, and I mean counts as norms, or what else? Because you somehow said that deontic norms especially, so I suppose that you consider other type of norms too.
No, actually this kind of modeling have been conceived for deontic norms, actually, because they provide constraints on the degree of liberties, on what the social realities can develop. So this kind of modeling is actually specifically focused for deontic norms. Other kind of norms can be dealt, but let's say for now it's an open question. So I would like to maybe with you to discuss about this kind of problem, because, for example, even sanctions or even other kind of norms could be represented in a similar fashion. What is important is to say that all the type of norms can be represented in terms of provisions. But when, in my view, let's say it's specifically something for deontic norms that you want to know if you are compliant or not. So that's why, let's say, this modeling is well suited, in my opinion, is well suited for deontic norms. But for other kind of norms, as I said, it's an open question, and we have to think about it.
Yeah, I would be very interested. I mean, because just those kind of norms which somehow look like deontic norms, but they talk about power, for example, and cannot really be reduced to deontic modalities. So it would be very interesting to check.
Yeah, you're right.
Yeah. Okay. Thank you. That I would be very interested. Thank you, Enrico.
Sure.
I do have another question for you, Enrico, but please, everybody, feel free to write as Reka did on the chat if you have any comment or question, or you're wondering how this might be relevant for the work that you're doing, or for a project idea that you have. And my question, Enrico, is like, so I've been doing ontologies and legal ontologies, so yeah. I know more or less what we talk about. However, like, according to you, how easy it is to learn to design legal ontologies in your experience? And does this difficulty, so the degree of difficulty, change whether you are someone with an IT background or someone with a legal background? And I don't know, what kind of suggestions, advice you would give to people that are at the first time in trying to use this kind of tools and approaches?
Yeah, no, I think that the interaction between a legal expert and IT expert is essential. When I joined this domain, let's say some years ago, I hadn't any, let's say, knowledge about legal aspect or philosophical legal philosophy aspect of the norms of the legal documents, but it was actually with the interaction of with legal expert that I actually saw the benefit of exchanging ideas with them. So from my point of view, it's better not to rely on IT only people, and also not only in legal expert people, because, for example, the bias that legal expert used to have is to escape every time from the modeling constraint. So it's a sort of let's say how can I say, a negotiation between these two kind of mentality, and as a result of this negotiation, I think you can achieve better results than sticking to a specific let's say approach more oriented from an expertise, a specific expertise point of view.
We do have another question from Marco, please. Marco, you need to unmute yourself. Okay, maybe not. I'm not sure. Marco?
I cannot hear.
Okay, maybe not. I don't know. Anybody else? Okay, Marco cannot, for the moment, join us. Yes, he will write he's writing to me the question privately. So just wait a sec. In general, what I was wondering also is what kind of integration with machine learning approaches, Enrico, you have seen and you think are the ones that we should develop in the next, let's say, 5-10 years?
Sorry, it's a question?
Yes.
Okay. No. I can tell you which has been my experience in this domain. Actually, since I come from the IT domain, my approach was at the beginning to start actually with machine learning or natural language processing to implement this kind of semantic annotation ideas. So, for example, we used machine learning for classifying portion of text in terms of provision types and to detect the attributes of these provisions using natural language processing. And in the last decade, we wrote several papers in this respect. It was actually later on where I started to go into deep details in the modeling process, the modeling aspect, and in particular in the reasoning aspect. What I can tell you is that again, it's a combination of approaches. The bottom-up approach, which is based on machine learning, natural language processing, or the top-down approach, which means modeling provisions, modeling norms, and then implementing such models for reasoning and for semantic annotation. So it's a combined approach that gives you, according to my opinion, the best results. It's a trade-off between them.
Yeah, we see that many approaches right now are integrating both of them. So it's very interesting to see where all of this is going. So Marco has provided me with a question. Actually, it's two questions, which is, So the tools described will they be likely be developed centralized or decentralized? More participants, in the sense that will more participants cooperate in the creating or making operative of the tools? So yeah, so it's about whether these are decentralized or centralized developed tools.
No, okay. The approach is, as I said, it's at the stage of let's say it's a theoretical approach for now, but it's being conceived to be decentralized in the sense that everyone can reuse data, let's say semantic data at a certain degree of details, and implement in a pure decentralized approach or pure federative approach the different kind of models that they want to implement. My proposal is that this can be possible models for dealing with services like, as I said, semantic legal information retrieval or legal compliance checking. But has to be conceived within the semantic web-oriented environment where different parties can be consumers of data provided by, for example, institutions like European institutions, but also national institutions or different kind of public administration.
And so since we're talking about this, if we had to take a more kind of worldwide view, do you think that, so as far as you know, how many parliaments, how many public administration, maybe how many is very hard, but in which countries is this movement for making legal knowledge, legal data, especially legislative data, accessible to everybody? How far are we in this process?
Actually, in the decade, let's say 2000, 2010, many different projects have been developed in the, let's say, so-called legal XML movement. And there are, let's say, the most part of public administration, for example, European administration were involved in this kind of this movement. But one of the key points, according to my opinion, and I would like to underline that it's my opinion, is that when the guidelines of the linked open data approach came into practice, we had a very big change in the perspective of how the semantic web should be developed, and in particular also the legal semantic web. In fact, even if there were many projects in the legal XML community in the decade 2000-2010, the efforts that were produced were not at the level of the result. So the result were not at the level of the efforts, sorry. So we had less results that we were thinking to have. On the other hand, in the semantic web in general, not in the legal, I mean, but in the semantic web in general, the advent of the linked open data guidelines produced a sort of boost for implementation of the semantic web concept in an effective way. So what I would like to say is that the adherence to the guidelines of the linked open data approach is the most, according to my opinion, the most effective way to implement a semantic web, even in the legal domain, which might provide much more results than the approaches that we had in the 2000, let's say, representing, for example, legal document with a specific XML schema or a specific XML representation. Because at the end, a legal document is nothing but a document made on a structure that can be represented in XHTML, and you have the semantics that, according to the linked open data approach, has to be represented using RDF and OWL, and that's it. And you have all the tools that are already developed in the semantic web community that you can use also in the legal community, in the legal semantic web community. And for example, the approaches that I have shown for legal information retrieval or legal compliance checking are using just general purpose tools, except for the specific legal oriented modeling, using OWL or using RDF.
Okay, so you mean it doesn't make any sense to make the efforts of actually annotating a lot of data if you're not using the official guidelines very precisely, because then the data is not the quality one that you want.
You don't have the tools. You have to develop tools. You have to develop an editor. You have to develop, let's say, a query language, because if it's not RDF, you cannot use Sparkle. It's and moreover, you are not interoperable.
Sure. So it's, yeah, huge limitations that makes it even useless or senseless, right? Yeah.
It's a big effort from the academic point of view, absolutely interesting and so on. But from the point of view of the results that you can achieve, I have concerns.
Okay. Just to go to the community before we close our event, is there any question, any comment? As any of you already use the tools that Enrico has been explaining to us, or I don't know, have you had an idea on how you could use this, or maybe you think that this is completely useless and you don't see what the application is? Do you have any last comment or any last question? Okay, so I will take it as we're hungry. So thank you so much, Enrico. I have to tell that, I don't know whether you noticed, but during your presentation at certain point we're even 41. And I must admit that this is one of the most successful events we've ever had. So we're worried of low participation rates online, but I don't know. So I'm thinking either people are really bored with this coronavirus thing, which is probably the case, or our incentive, our usual incentive that we have with the networking activities, which is beers and food, is not as strong or as encouraging as we think it is. But I'm super happy that many people stayed online till the end. Thank you so much, Enrico, and thank you so much for the whole community to be here. I just want to say one last comment. So as I was saying at the beginning, I will share my screen just one sec so I can give you the references. Give me one sec. Voila. So you should be able to see it now. So these are our links if you want to stay up to date with our events. And I was mentioning we will have special events even next week on April 1st. I'm going to draft the event on Meetup tonight, which is going to be, it's about a very beautiful initiative of some people that have created a chatbot which is able to answer legal questions related to the coronavirus. I'm thinking about, of course, all the work-related questions. Workers' rights. I think it must be a very messy situation even for a human. So I don't know how a chatbot can answer that. But if you're interested, and if you don't have better plans, then we're going to be online in this modality even next week. And if you would like, so as I was mentioning at the beginning, we're going to, so we have registered this event. We're going to maybe even share the link, share the slides of Enrico, if you're interested. And I would say that that's it for the moment. So we still have a last question, Is there, from Daniel, is there any professional code of conduct or laws that can guide us while using semantic tools? I don't know. We will leave this, Enrico. If you want to give us an answer, we'll send it to Daniel later on. But I really thank you for being with us tonight and for your presentation.
Thanks a lot, Arianna, for your invitation, to all the other participants. I do hope that we can have the opportunity to meet in person next time.
Yeah, we're going to organize something in person for sure.
We have to drink this beer at the end.
We have to drink these beers, yeah. We will. Thank you so much, Enrico. Take care, everybody. And see you soon, I hope.
Thank you very much. Bye. Thank you. Bye.